All right. Well, I'm glad I've got a few people to speak to tonight, but we're actually recording this not just for the folks who are on here, but also for the folks who are going to be watching this later. And I do get quite a few messages of folks who ask me questions about the um, the videos that we put out. So I know folks have a hard time getting online, and eventually we might just cut down to like 1 or 2 Zoom calls a month and do most of our stuff by just posting through videos. But I do enjoy giving folks a chance to get on here and ask questions. So tonight, what we're going to talk about is a couple of things. First, we're going to talk about why people are so frustrated and what they can do about it, and why folks are losing, whether they're going up against a criminal case, a civil case, or they're interacting with police officers or CPS agents or any other entity of the government or agency of the government. Folks feel like uh, it seems like the government is this big tyrannical power, and that nobody can beat it because it's so big. Okay, that is actually its weakness, and it is easy for you to beat it. You've got David and Goliath, the story of David and Goliath, and I've seen several different approaches to explaining the story of David and Goliath. But the fact of the matter is, the small dude took on the very, very large dude and beat him. Okay, and he beat him with one small thing. You only need one small thing to beat them, and the things that are available to you are readily available. They're not that difficult to find, and I'm going to lead you to them tonight. Um, Now, my answer to where to go will change in a few months when I have a website fleshed out and I have things put into an order that I would love for folks to be able to follow along with. However, we don't have that right at this very moment. So I'm going to guide you some resources outside myself, resources I've used, resources other people who are winning have used. And I'm always open to resources that get results. I'm a results oriented type of man. If it does not get results, I don't like using it. I will try something, see if I get results. If I don't get results, I move on, or I reconfigure that thing to see if I can get results. And if it doesn't work for me, I don't push it. And things that don't get results, we've talked about before, the sovereign citizen movement, a lot of the stuff they do does not get results. Going in with a chip on your shoulder and an ego, it does not get results. The very first law book is scripture. If you want to read the very first law book, read scripture. It's all there. But it seems like the government agencies and these government agents have this mystifying and awesome power, and that they're unbeatable. Everyone fears knock at the door. It's like the scariest thing to have somebody knock at the door and for that person to say, I'm here with the government and I have a question. And it's the easiest thing in the world to handle. We have been tricked and fooled into thinking that they aren't beatable, and it's not true. Now, can you get hurt if you don't know what you're doing? Yes, you can. You can get hurt if you don't know what you're doing with a piece of equipment. Try using a tractor and not knowing how to use it. You can kill yourself quick. A lawnmower can cut your fingers and your toes off. You need to know what you're doing, but when you know what you're doing, it's very easy to get your way. And it's not that difficult to learn this stuff, to make yourself a formidable opponent, to get to where they don't want to mess with you. Okay. And I've been there. I've gotten to that point. I've been in federal court. I've stood before sheriffs and CPS agents, and I've gone backwards and forth with the Internal Revenue Service. I haven't conquered it all. There's no way I could do that in a lifetime. And I'm certainly not going to go out and create a whole bunch of trouble for myself so I can become great at beating things. I'm not going to go out and intentionally get myself arrested. If it comes my way, great. But I think that to go out and intentionally look for trouble is definitely not what the Creator wants us to do. We are to do His work. And if we run into problems while doing His work, He has remedy for us. He has a way for us to handle these things. The government has made the rules very difficult to understand. So if you go and try to read what we call law, it's very difficult to understand the wording, and that is intentional. It's very intentional. They want you to think that you have to have a 12-year degree and then a 3 or 4 year law degree on top of that costs $100,000 in order to go into a courtroom and stand up for yourself and to say what you need to say and do what you need to do and file what you need to file. That is not only patently false, it's propaganda. Don't listen to them. You can get remedy. You just got to learn how to fight. And it's not even fighting. You don't even want to go in there like you're fighting. The worst thing you do is go in there and fight. Okay. Um, so the rules aren't that difficult to understand. Now, I'll tell you what is difficult to understand: the legislation. The legislation can be difficult to understand, but because they've made it so difficult, that's also its weakness. Goliath was huge. He probably didn't have much fighting experience. I've known really big guys that have never been in a fight because they're so big. Nobody messes with them. Get them in a fight, and a skinny guy can beat the tar out of them. I've seen it. And so let's read what Scripture tells us about lawyers first off, because everyone thinks they need a lawyer, right? And the Bible tells us, "My people perish for lack of knowledge." Notice that it does not say, "My people perish for lack of a good lawyer." That is not what Scripture tells us. So I'm going to read the Berean uh, Bible version of Matthew 20, Luke 11, actually. Luke 11, and it's going to start with number 43. Woe to you, Pharisees. Now, you've got to remember who the Pharisees were. They were the lawyers of the time. Remember, the law was the church. The Pharisees were the ones who interpreted the law. They were the lawyers. As a matter of fact, in the King James Version, they interpret the Hebrew to say lawyers. Woe to you, lawyers. You love the chief seats in the synagogues and the greeting in the marketplaces. Woe to you, for you are like unmarked graves, which men walk over without even noticing. One of the experts in the law told him, "Teacher, when you say these things, you insult us as well." And Jesus replied, "Woe to you as well, you experts in the law, you lawyers." He replied, "You weigh men down with heavy burdens, but you yourselves will not lift a finger to lighten their load." Listen to that again. You weigh men down with heavy burdens, but you yourself will not lift a finger to lighten their load. Woe to you. You build tombs for the prophets, but it was your fathers who killed them. So what were they? They were, word for that, it's not coming to me, hypocrite. They were hypocrites. You build tombs for the prophets, but it was your fathers who killed them. So you are witnesses consenting to the deeds of your fathers. They killed the prophets, and you build the tombs. Because of this, the wisdom of God said, "I will send them prophets and apostles. Some of them they will kill, and others they will persecute." Okay? Woe to you, experts in the law, for you have taken away the key to knowledge. You yourselves have not entered, and you have hindered those who were entering. I'm going to read that one more time. Woe to you, experts in the law. Let's just replace that with the King James versions. Woe to you, lawyers, for you have taken away the key to knowledge. You yourselves have not entered, and you have hindered those who were entering. Okay? As Jesus went on from there, the scribes and Pharisees began to oppose him bitterly and ply him with questions about many things, waiting to catch him in something he might say. Does this not sound like the modern court system? It hasn't changed in allegedly 2,000 years. This is our modern court system. Woe to you, lawyers. You have placed burdens upon man. You've taken away the key to knowledge. How have they done that? They've made it seem like to the average person it is too complicated for them to understand. This is so far from true. Okay. Now, the problem folks have is they get angry. I understand that. That's part of the process. You got to get a little angry at first. You got to get angry. There's nothing wrong with that. But you got to get past that anger. You have to remove the chip from your shoulder, and you have to understand that these courts are not dealing with you. They have tricked you into thinking that they have jurisdiction and control over you, but they don't. Okay. Now, that doesn't mean you run into a court and start yelling, "I'm a man, you have no jurisdiction over me." It will not work out well for you. Scripture tells us here, they say the same thing. Okay, listen to this. "I send you forth as sheep in the midst of wolves. Be therefore wise as serpents and harmless as doves." Does harmless as doves mean that you go into a courtroom and start yelling at the judge that you're a man? He knows. You don't have to tell him. He knows. Okay? He knows what's going on. And you stating that you're a man on the record does nothing for you. I keep seeing folks who say, "Just go in, tell them you're a man, you're not the name." They're going to move on and continue on. And if you aren't the name, what they're going to do is issue a failure to appear. And then there's going to be a warrant out. And then at some point, you're going to get pulled over because 90 to 95% of all the average person's confrontations with law enforcement come through a traffic stop, and they're going to find out your name. Why? Because you're probably going to tell them. You're probably going to hand them a card with your picture and name on it. That's a problem I've already addressed. But you know what? I'm not going to tell anybody that they shouldn't drive around with a license. As a matter of fact, you can. Nothing wrong with it. I don't think that if you don't want to get rid of your license, if you have nothing against the license, if you need the license to do your job, keep it. There's nothing wrong with that. You just need to know. You have to study. You have to learn a little bit. And it's not that difficult. You don't have to spend the next 2 years spending 8 hours a day studying. Replace your TV and movie time with a little bit of time in the mornings studying, and you will have plenty of knowledge to take care of yourself in your actual matters. Okay. Now, does I send you forth as sheep in the midst of wolves tell you anything about how you should go into court or how you should deal with a government agent? Okay. Don't be mad. I've seen instances where a CPS agent or a cop has walked up to someone's door, knocked on it, and they've said, hey, I've heard about this, or this is the problem, and we want to ask you some questions. And people fly off the handle. How dare you? I have constitutional rights. You just can't come and knock on my door and start asking to come in and look at things or see my kids or whatever. Yes, they can. If you have a front door with a sidewalk leading up to it and no fence and no signs and no gate, anyone can walk up to your door and knock and ask you to come in and look through your underwear drawer. They can. I mean, what do you want people to do? You want more laws? You want a law that's against that? Oh, we need more laws, huh? Is that what we need? Is more really going to solve your problem? No, it's not. The problem is we got too many laws, right? But you don't need to know all the laws, okay? You just need to know some basic knowledge, and you can get that basic knowledge fairly easily. And yes, any police officer can walk up to your door, knock, and come ask to search. What should you tell him? Well, some say you should tell him to go pound sand, and there's nothing wrong with that. Some tell him you should be really nice and not give them cause to be upset. I say that you probably stand up for yourself, be firm but polite, and be wise as a serpent but harmless as a dove. The first thing that always comes out of my mouth anytime somebody with any type of authority approaches me is, how can I help you? I don't care if it's a cop on the side of the road, somebody with a badge knocking on my door, a judge in court. How can I help you? What can I do for you today? That's what a creditor does. That's what kings do. They solve problems. How do you solve problems? You ask questions, okay? And as long as you're asking the right questions, you really don't need to make statements, and you don't even need to make any statements usually, but there may come a time when you need to make a statement. And as you get along further in your studies, you'll know when that time is, okay? Now, real quick, we're going to study what's actually going on, because I'm really sick of people telling me to come into a court and enact a common law court. The common law court is gone. It has been codified into statutes. It's no longer there, okay? It is there in the background. They're supposed to follow. But going in and saying, I want a common law court's not going to do you much good either. They're going to push forward. So what happened? Okay, before 1938 or thereabouts, we did have a common law court. In a common law court, you can, or in a common law system, you can't compel performance. Meaning, I can't make you wear a seatbelt driving down the road, okay? That's compelled performance, okay? But that system is not what the system is that we are in. Those are not the courts that we are in, okay? So, what kind of system are we in? Well, prior to 1938, in courts, you were dealing with public law, okay? And since 1938, the Supreme Court has only dealt with public policy. That's different, right? Public policy statute, not public law, right? And trying to quote a case prior to 1938 usually doesn't gain you much favor in a court. It's usually ignored. It can be used. Generally, I try not to do anything in court with a case prior to 1938, unless you can't find anything about it after 1938, okay? In 1938, there was the case of Erie Railroad versus Tompkins. During the case of Railroad versus Tompkins, that was the year that they blended law with equity. You need to be familiar with these terms. If you don't know what equity is, go look it up. It's not that bad of a system. It doesn't have to be our enemy. None of this has to be our enemy, Okay. A man sued Erie Railroad because he was standing beside the train tracks and there was a board sticking out of a car. The train went by and darn near killed him, about took his head off. So he sued and he lost. You have to forgive me. I have a little bit of sinuses. So prior to 1938, the courts would have ruled for the man because he was damaged. After 1938, what they ruled in the case of Erie Railroad versus Tompkins is that the man lacked standing to sue the company. Now, under common law, he was damaged and he would have had a right to sue. Okay. Now, after this, what they said was there was no contract between Erie Railroad and this man. Okay, so we've moved our form of law at this point. A lot happened in the 1930s. And you'll have to dig into that on your own because it's a whole big thing. It's fun to read about. Won't do you any good to go to court and yell about it. Okay, it's nice to know. Won't do you any good to yell about. So we went actually into in the Erie Railroad case, the Supreme Court ruled that all federal cases will be judged under the negotiable instruments law. Okay, dollar bills are negotiable instruments, bonds, negotiable instruments, criminal charges are negotiable instruments. So what we have here is a blending of law with equity. All right. Now, all our courts since 1938 are basically what you might call merchant law courts. All right. And they're operating in admiralty jurisdiction. Now, the thing is in 1930s, this nation was foreclosed on. It's bankrupt. There is no more gold and no more silver. There is, but it's not being used for circulation. They actually rescinded. They made everybody turn it in. It was illegal to own those coins up until about, I think, 1974, 1969, somewhere in there. They changed it. You could have some of these coins. So all the stuff that you have now is without any substance. The dollar bills are a military currency. They're without substance. Okay. So America is completely owned by its creditors, but they don't want to say that. That's a very embarrassing thing for them to say. The creditors do not want people to know that they could foreclose on this nation at any time. It's not something to be afraid of. It's just truth. So now we have courts operating under admiralty jurisdiction. But if you go in and start yelling about admiralty jurisdiction, it's not going to get you very far either. They're going to tell you that they're operating under statutory jurisdiction. Okay. Now, have you ever heard the phrase color of law? Color of law means that you color something in to make it look real. Okay. So I can color something in and make it look like it's real, but it isn't. If you have someone who is trying to give you, who is trying to cause you troubles because they're showing you, they're saying that this is a law when it isn't, that's acting under color of law. Go look that phrase up, color of law. And the problem is they don't want to admit that we're under admiralty jurisdiction. They give us the signs everywhere, like the gold fringe flag. Okay, but if you go in and start talking about this stuff, you're just going to be asked, are you a sovereign citizen? And you're going to have to go down the whole road of, are you crazy, and all this other jazz. Try to avoid that. You can handle it, but why invite it? Okay, so the problem with operating in admiralty jurisdiction is, in order to bring you into court, there would have to be an international maritime contract. If they told you that the court was operating under admiralty jurisdiction and not common law, your defense against any alleged charge would be quite different. So they don't say these things. They want you to go in and think that you're under a different jurisdiction. Okay. So when you start using these arguments, they'll usually either A, ignore them, or B, tell you if you don't stop using that argument that they will get you for contempt. I once had a young lady go into traffic court, because traffic courts are fun ways to play. And one of the questions she asked, because I was curious, at the very beginning, at the onset of this, was, Your Honor, can I use a constitutional argument in this court? Now, this is a traffic court. It's a statutory court. And his response was, I cannot hear a constitutional argument in this court. What does that tell you? It tells you that you using a constitutional argument in a statutory court won't buy you a cup of coffee. So don't go there yet. Until you understand this stuff, those arguments are moot. Okay. There may be a time to use those, but you're going to have to change the nature of your approach first. Um, so what are we operating in? We're not actually operating in a state. We're operating in a what you might call a colorable admiralty jurisdiction. Okay. Um, so contracts are enforceable, and the Constitution gives us two jurisdictions where contracts can be enforced: equity or admiralty. But we find them being enforced in statutory jurisdiction, and that's very embarrassing for the courts. You can use that, but you have to understand what's going on. Okay, a little studying, and you can figure this stuff out. It's not that difficult. All right. Now, since we're operating under statutory, it's more of a colorable admiralty jurisdiction. And this is where we get into the UCC, okay? And there are ways to get the judge boxed in court using arguments under the UCC. I'm not going to go into those right now. Those arguments exist, and I'll tell you where you can find them, okay? It's very important to understand UCC 1-308. When you sign your signature, if you sign using just your cursive signature, you're giving the other party a blank check under colorable admiralty. Press any and all charges against that person. And in the court's eyes, your body and that legal name are the same entity. That's why the assumed name certificate is so important. Once you understand what you're doing by abiding by the law and registering your fictitious business name that is known as your legal name, you have government documents evidencing a split between the name that refers to you in the private and the legal name that refers to you in the public. And by doing that, you put the courts in a very, very difficult position. But nobody's doing this. Well, there's a few people doing it, but the only ones I know doing it are the folks that are in my very close-knit, tight circle. And there are three approaches here to your learning that I'm going to give you, okay? And one of them is a group that most of their stuff is free. You can do a subscription. And usually I do not tell people about things that require payment, okay? I think most of your learning should be free. However, in a few cases, those things are very well worth it. Number one, and I know you guys are probably tired of, the regulars are tired of hearing this, is jurisdictionary. Dr. Graves put together this course called Jurisdictionary, something you must understand about lawyers in law school. Okay, but first think about everything you've done professionally. You probably went to 6 years of middle school or elementary school, 2 or 3 years of middle school, maybe 5 years elementary, 3 years middle. I don't know. They break it up different in different places. And then you went to high school, totaling 12 years. And then after that, many of you went to another 2 to 4 years of college. Some of you 6, some of you 8. Okay. In all your 12 years of initial primary schooling, how much of what you learned do you actually use day to day? They've stripped it down so much that they make you think you're going to know a lot, but all the things that you would know that would make you a good adversary in court or against the public have been taken away. Why? Well, because it's the public that's doing the schools and it's the public that's implementing the system. The public isn't you and me. The public is a jurisdiction. So you see the police cars that say protecting the public, and then you see the Supreme Court cases where the Supreme Court rules that the police have no obligation whatsoever to protect you. That's not contradictory. That's true. The public is a jurisdiction, and a police officer, an officer in the corporation, is there to protect the corporation. He's there to protect that jurisdiction. He's not there to protect you. They're not your friends. They can help you if somebody's beating your head off and they show up, but odds are they're going to be coming to pick up the pieces and charge anybody they can charge with anything they can charge to make money, because that's what they do. Okay. And once you understand that, life becomes a little easier. Stop depending on lawyers to defend you, police to protect you. You got to do these things for yourself. Okay. So lawyers study procedure. They don't study law. Very few lawyers know anything about the law. Here's a short story. I had a spouse who was moving from one state to another, and she had children. And those children had a different father. And under their family law court, she was obligated to notify him and the court that she was moving. She actually had to get permission from the court. How do you get permission from the court? You serve the other spouse with a notice of intent to relocate. They have so many days to respond. And if they've not responded, if they've not objected, if it's okay with them, which non-response is agreement by acquiescence, then you can move. Okay. Now, in this particular state, statute said that you had to give 60 days after the notice before you can move. But if you read a little further down in the law, there was a spot that covered circumstances outside of that where you would only have to give 10 days notice. Upon a little studying and reading of that one page of law, I wrote up a notice of intent to relocate, handed it to her and said, here you go. Mail this via certified mail, return receipt requested to your ex. We'll go file this into the family court case. We'll wait 10 days. If nothing comes of it, you can move free and clear. Now, she didn't trust that, so we went to an attorney. I'm not going to go through the little hassle of going in to see this attorney. Let's just say that what he was doing prior to us getting there was very unprofessional, and the young lady that walked out of his office was obviously there for more than a consult. We go into the court or into the office. We sit down, and the guy says, what can I do for you? And I said, well, this is what we're doing. And if we need to file a notice of intent to relocate. He's like, okay, you're going to have to, I need a $1,800 down payment, a retainer, and then it's going to be like $400 to file the paper. And I said, well, here's the deal. And he said, oh, you got to give them 60 days. I said, no, actually, in this case, we only need to give 10. And he argued with me. He said, no, I know the law. It's 60. And this guy was a family law guy. He had it on his sign. He practiced family law. He practiced several forms of law because it was a small town, but he practiced family law. So hold on just a sec. I got to plug my computer in before it dies. And so he proceeded to lecture me on this. And I said, do you have the law book? He said, of course I do. And he goes to his bookshelf, pulls it off, flips open to the page, points at a particular section, shoves it across to me. I flip the page over, point to another section, and shove it back to him. He reads the little bit down below, the stuff that he'd always read, and he looks up at me and he says, I'll be darned. I've been doing this for 13 years, and I had no idea that was in there. Lawyers don't know law. You will always have a better interest in what you're doing, and you'll have a better outcome if you dig into it yourself, because you have a vested interest in your outcome. He's an officer of the court. Okay. His first obligation is to the bar. His second obligation is to the court. And you're way down there at number 3. Okay. And if he's a greedy guy, you're way down there at number 4 because himself is up on top of that. So you got the bar, the court, him all ahead of you before he does anything that's of interest to you. Okay. And I have paid lawyers to do things. And if you don't pay them over and above what they're asking for, you won't get anything other than the bare minimum. That's okay. You just need to know this before you go in. Does that mean you shouldn't get a lawyer? No, you can get a lawyer, but study enough to know and write your own motions up. And then you hand the stuff to him and tell him what to do. And then you've got a lawyer, but then you're the one in control. You're the one controlling the attorney because you don't want the attorney controlling you. Okay. And if you're tight on money, you're not going to want to pay an attorney $250 an hour. It adds up quick, very quick. If you've ever retained an attorney, I know a woman who spent $20,000 on an attorney for her kid. He's probably still going to get 7 to 10 years. So lawyers study procedure, not law. You can learn procedure in 6 hours. That's it. You can learn the procedure in 6 hours. Now, if you want to dig in deeper, you most certainly can, and you should. You should learn about how to motion the court. You should learn about the rules for evidence. You should learn about where to do your own legal research so that you can pull up your own local rules of the court. Most court rules are only 15, 16 pages long. It's not that hard of a read. They make the rules very simple to read because the attorneys have to know them. Most attorneys aren't as smart as you think. It does not take a rocket scientist level of IQ to be an attorney. Trust me on that one. So what's the second thing that I'm going to tell you to do right now if you're in a bad spot and you need to learn quick? Go to YouTube, find the group called You Are Law. It's urlaw.org. But they also have stuff on YouTube. UR Law. Listen to the stuff they have. They're solid. The guy's solid. It's good stuff. It really is. Okay. If you're trying to crash course right now, jurisdictionary first. You can sit down and digest that in a few days. You can do it in a few hours, actually. But if you're like me and you like to go slow, it's going to take you just a little bit. Give yourself a week to do it. Okay. Jurisdictionary, not that expensive. It's less than what you would pay for an attorney for 1 hour. UR Law is your next bet. He has tons of tips and tricks. This guy's been at it for a long time. The third thing would be to understand the registration of the name. Once you have gone through those three things and you have a mediocre amount of knowledge, you can go to court and not be beat. And you don't have to worry about going to trial. You really don't. There's only about 1% of all cases that ever go to trial. Okay. You can do 99.9% of your court work just by filing motions. That's it. And it's not that difficult to write up a motion. If anybody thinks that a motion is difficult to write up, I'll send you a few. It's written in 7th grade English. It's not that hard. Okay. So 3 things you can do is jurisdictionary, UR Law, and understand the ANC. And I've put a crap ton of stuff on our Facebook page, Common Law Conversations. Now it's Uncommon Law Conversations. And my YouTube channel about understanding the difference between you and the legal name, because you are not the legal name. And there are motions that we have covered in some of our videos that you can file into a court case that are going to totally back the judge into a corner he's not going to want you into his courtroom. Okay. And eventually what's going to happen is the other side's going to come to you for a plea deal. If you understand that, you understand jurisdiction, which we've gone over that. I think either the last video or the one before that, we went over the private versus public. And in one of them, we went over the private administrative process. If you've got that stuff, you're going to be hell on wheels in any type of contention, any type of commercial matter. Okay. So at this point, if anybody has any questions, there's not that many people on tonight's call. That's okay. I only need one person to talk to. And I can talk to myself, frankly. I do that a lot too. But if anybody has any questions, throw them at me. Otherwise, call it a night. It's up to you. Cool. Thank you, guys. You all have a great night. And I'll get the last video up online soon. And then I'll get this one up.